In most cases, if a loved one dies from medical malpractice, families have the power to sue. I'm Tisha Powell.
And I'm Lee Zurich, but in one of the most visited states in the country, that's not always the case.
We're talking about Florida and its Wrongful Death Act. The law says if certain people with no spouses and no children die from medical malpractice, their family can't sue for pain and suffering, only economic damages like funeral expenses and lost earnings.
Investigative reporter Kristin Crowley traveled across the state to hear both sides of this controversial law and its impact on anyone living or traveling to the Sunshine State.
Lee and Tisha, when our work on this story began in early January, years of efforts to repeal that law that critics called free kill consistently failed. But as we continued our reporting, support to undo this law grew to a level the state had never seen before. But would it be enough this time? Before we answer that, we show you how our reporting began on a decades-old law unlike any other in the country. Just looking at Taylor Jenkins.
She was just living her best life, pouring love into other people. She was such a ray of sunshine.
And Keith Davis.
My dad was an old soul, and he loved to play the acoustic guitar. He loved animals.
You may not see they have much in common. Taylor was 25, a flight attendant. Keith, 62, a Navy veteran. But their loved ones say they share a devastating bond of injustice. You had no idea this law existed?
Had no idea, and I work in healthcare.
It still hurts really bad.
In 2020, Sabrina Davis's father died from an undiagnosed blood clot in his leg. His death ruled a result of medical malpractice. 3 years later, Taylor, who was in a car crash, died from internal bleeding. Her mother, Cindy, received a sworn statement from a medical expert saying her death was also a result of medical malpractice.
In reviewing her record, I know that she had laid there in that bed losing blood for 15 and a half hours because the torn artery went undiagnosed for so long.
But Sabrina and Cindy say neither of them could get justice because in Florida, the law doesn't allow it. This is that law. A portion of Florida's Wrongful Death Act, passed in 1990, allows families to only sue for economic damages in medical malpractice deaths, which can include lost wages and funeral expenses. But it bars lawsuits for non-economic damages like pain and suffering if the victim has no children under the age of 25, isn't married, and is 25 years old or older. Cindy's daughter and Sabrina's father both fall into that category. It has earned the name from critics, free kill.
You are getting a free pass, which is why we say free kill. This patient is no longer here because the standard of care was not followed and it cost their life. You have no accountability. You got a free pass. This was a free kill.
Why are the damages for pain and suffering so important to families?
When an attorney can only recover for economic damages, they can't afford to take the case.
Meaning families can't go to court and can't hold doctors accountable.
If they cut off the wrong leg, you can sue. If they cut off the wrong leg and let you bleed to death and die, you cannot sue.
Jed Kurzban is a medical malpractice attorney and one of nearly a dozen attorneys Cindy contacted for help.
So this was Mother's Day 2022.
Every one of them gave her the same answer. We can't.
This law must be changed. It is truly a travesty.
Does this law only affect Floridians?
No, it affects anyone who's been malpracticed on in Florida. I get those calls every week. We came to Disney, we took a cruise out of Tampa, we took a cruise out of Miami. This thing happened. What can we do? In Florida, nothing.
So how did a law that doesn't exist in any other state across the country pass in the first place? Legal experts told us it was to keep medical malpractice insurance premiums low so doctors wouldn't leave the state. Cindy says there's a better fix for that.
You want to lower malpractice premiums? Stop the malpractice.
Good afternoon. The Committee on Judiciary will now come to order.
The fight to change the law has ramped up in recent years in Florida's capital city.
To me, it comes down to fundamental value of life. It should not matter someone's age, the age of their children, their marital status.
State Senator Clay Yarborough has signed on to multiple bills to undo the law. None has passed. He says one reason is concern lawsuits will skyrocket.
Do I want to see more lawsuits? Absolutely not. But do I want to make sure we maintain accountability? Absolutely.
Even still, he doesn't think an outright repeal will pass, which is why he sponsored a bill with caps, a limit to how much money families can collect.
I think Senator Yarborough has come up with really what I call a grand bargain. Those individuals would now be able to bring this lawsuit.
William Large with the Florida Justice Reform Institute is a former medical malpractice defense attorney and worries repealing the law would be a financial disaster for doctors, hospitals, and insurers.
What about other states in the country that don't have laws like this?
Several states have caps on non-economic damages.
26 states have caps for medical malpractice, ranging as high as $2.25 million in Nebraska and as low as $250,000 in California. Illinois was among this list until 2010, when the caps were deemed unconstitutional. The effect of losing them? The Illinois Trial Lawyers Association told us medical malpractice cases actually dropped 5%.
This is his dog tag from the Navy.
And some families say while they want the law changed, adding caps is not a move they can support.
In my heart, I know that no one can put a price on my dad's life.
I would give everything I own. They could drop me off on a street corner and take everything from me, and I would let them do it if I could have my daughter back.
Our interviews with experts and families about this law started in January, to the surprise of many of them. On May 1st,
33 yeas, 4 nays, Mr. President.
Show the bill passes.
Legislators approved a full repeal of the law, no caps. Cindy and Sabrina were thrilled until.
That's going to lead to a flood of lawsuits against practitioners and against hospitals.
Florida Governor Ron DeSantis announced he would veto the bill, marking an end to this battle.
Here is my daughter in a box on my dining room table.
But families say it is not the end of their fight.
My dad was willing to give his life for this country and for our freedom, and it may not have happened on the battlefield. It may not have happened in a submarine, but it happened. I feel like it's the least that I can do to keep fighting.
DeSantis went on to say he would support legislation that includes caps on the amount of damages people could sue for. The families we spoke to maintain that is not a fix and will not bring justice to malpractice victims. It is important to note the Florida Supreme Court ruled caps on non-economic damages for malpractice are unconstitutional. It is not clear what would happen if lawmakers tried to add caps to this legislation. If a law did pass, it would not be retroactive, meaning none of the families you heard from could sue.